Yeah, thanks. Very quickly, just a sort of summary what Pillar 1 is supposed to be doing, and then a quick rundown on the things that we are currently doing. Some of them we building on things that already were reported in the annual report that you saw. So the aim is to analyze how laws, regulation, and other forms of normative shift system shape design practices, shape the way we trust in AI, and with that also the sort of somewhat ambiguous role that law can play in that field of trustworthiness. So on the one hand, it is a relatively traditional doctrinal analysis. What laws are out there? What do they capture? What aspects of autonomous systems do they address? Which ones do they not address? Do we have any reasons to believe that some of these regulations are successful? Do we have any reason to believe that they are unsuccessful? But also on a sort of slightly more abstract level, the question, what role does law and regulation play at all in creating trust? And that is not straightforward. You might say, okay, obviously we are now moving on Zoom, which is a much less risky meeting space than a physical meeting would be. But if we were to meet in a physical meeting, and you ask yourself, how can we trust Burkhard not to viciously attack us and beat us up? Then obviously, I would hope, the question is not, or the answer is not because the law prohibits it. You do not, I assume, at the morning when you go about your work, read through the latest version of the criminal code and take a sort of tick box of all the things you are not supposed to be doing. And you would not trust a person who relies on these rules exclusively, sort of Dexter type person who is law compliant, but maybe precisely because of that, not essentially trustworthy. So on the one hand, we are having this more mundane question of how do laws at the moment shape shape autonomous systems? How does the law respond to them? But also the more philosophical, slightly deeper question, how exactly do trust and regulation and law work in tandem or potentially even hinder each other? So the outcomes are, we want to understand the existing regulatory regime. We want to find out its strengths and weaknesses, which things work, which ones do not work. We want to assist in developing new forms of regulation, potentially better regulation, influencing the legislative process, but also assist developers who've now become a more prominent subject of regulation, how to implement legal provisions, how to build legal compliance by design. And we also want to communicate to a wider public these findings so that the public discourse around AIs, around autonomous system is more informed by real data, by rationality, rather than the latest movie depiction of that technology. So that is broadly speaking what we set out to do. And I've divided up the talk or the presentation into two broad categories. The first one is generic questions and projects that cut across our various intended applications. And the second part drills down at specifically medical devices and autonomous vehicles, but also some of the other applications that have come up in the process of our work as fields of interest. So let's start with these top-level projects, these top-level activities. One of the obvious changes that happened ever since we received our funding was that the AI Act was submitted to the European Parliament as a proposal at the moment, and we will talk about that in the afternoon much more in detail. But quite a number of our activities have sort of pivoted around that proposal, which at the moment is the most comprehensive suggestion for legislation but also already is copied by a couple of other countries. Australia is apparently working on a draft. The US has now instituted its own expert group on drafting something similar. And for the UK, that also obviously means there's now a real risk that the UK approach will fall between the gaps that are left between in the regulation that in the main trading blocks are pushed forward. So we had an expert workshop, and we continue to use and develop on the insights and results that that workshop delivered. We are still working on a write-up of the workshop itself, possibly in the form of an extended blog or some other way to feed that back into not just the node, but the TAS network in general. In a more specific application, we are feeding results from that workshop to the expert group on new technologies in policing, in particular automated real-time biometric identification. One of the things Police Scotland had expressed specific interest in, but generally using some of the discussions we had surrounding that act in the workshop and the follow-up discussion to see how the response in Scotland in particular to some of these technologies can shape. And we started liaising a bit with the Ada Lovelace Institute on that as well. Former colleague of ours, Lillian Edwards, is now working with them very intensively on response to the AI Act. And we hope to also help with the expertise that we have and are generating as part of the work in our node. One of the issues that the AI Act raises as well is one of democratic legitimacy and subsidiarity. And again, we will see a little bit of that in more detail in the afternoon session. So two problems that I have in particular with the Act, I think Chris shares some of these concerns, or generally we share these concerns. One is the significant role of standards and standard setting institutions and their legitimacy. Is it appropriate for legislator to defer details to these types of private sector institutions? What exactly happens if what they propose as standards clashes with fundamental values, including human rights? Is there an emerging conflict potentially between the jurisprudence of the courts, including the European Court of Justice, and this type of value-laden decision-making that we find in these standard-setting institutions? So general interest in standards, to what extent values are or are not reflected in these standards, and the way in which it is appropriate or not appropriate for legislators to defer to them. The second issue that we have with the AI Act is generally the role of subsidiarity and multi-level governance. It seems that this act might preempt more rigorous legislative proposals and regulation by the member states. Now, that is not primarily a problem for the post-Brexit UK, I would say, but still we obviously face the same question on who is the right level of regulator here. Should it be the UK? Should it be the devolved parliaments? Should it be an international regulatory framework? And the AI Act, for better or worse, makes a couple of decisions here that are worth exploring, analyzing, and also seeing how they actually pan out. So AI raises issues of how do we in a democracy regulate it, but they also pose more direct problems for democracy, and that is again particularly Chris and Phoebe and our colleagues there looking into problems of challenges to democratic legitimacy through these technologies themselves. So we get a sort of closed circle or feedback loop here in the sense that AI is a problem, trustworthy AI is a problem, partly because in its regulation we want to maintain certain standards of democratic accountability and governance. And at the same time, that very AI poses dangers and problems for the regulatory process. A sort of a feedback loop is built in here broadly under the theme AI and democracy and democratic accountability. That also closely related raises questions of AI and the rule of law. How and under which condition is it appropriate to defer to the legal system here? And what legal system do we have in mind? One with or one without AI? So we sometimes say these technologies can be made trustworthy because there's a robust legal system in the background that ensures attribution of liability and recompense and all that. And at the same time, that very legal system is in itself subject to potentially considerable changes through the use of AI. So another problematic feedback loop that we are investigating. One thing that happened just last week is that we finally put a report on principles of ethical use of AI in the justice system to Atomium. The plan had originally been to have a launch event with members of the European Commission and the European Parliament there. Unfortunately, that was not possible due to COVID. Was a couple of times delayed, and eventually we decided, or Atomium decided, rather to publish all the principles rather than to wait what the situation might be. But we are in discussion with Atomium on a fourth reiteration of our research we did with them. But these principles are now officially published. And we as authors are also considering a more academic write-up in the form of a paper. And on the practical side, we are working with the Law Society on accreditation procedures. What does it mean to be competent as lawyer in the technology field? What level of understanding do they have to have in order to do their job properly? So we are already feeding some of these results from the principles into the practice of the Law Society. One thing that came up relatively recently is a sort of student-led activity that we are trying to shepherd in Edinburgh under the TAS umbrella. It is a possible AI bias clinic along the lines of the more traditional law clinics, where citizens get legal advice from students under the supervision of some more senior academics and ideally people who have a license to practice. So we are exploring at the moment the possibility to work with one of the student-led activities on an AI bias clinic where citizens who have been negatively affected by one of these systems can get legal advice and support. And finally, again, in terms of the intersection between the legal profession, law schools, and the future of legal training, Daria, the research associate on our pillar, is also heavily involved with organizing an early career researcher conference in conjunction with Scotland, the Scottish Network for Innovation Technology Law. And we anticipate that conference, which will be in the summer in Edinburgh, to have also some task-dedicated context stream where younger researchers across the UK, across Scotland, will be able to share their ideas and interact with the TAS team. One theme that also emerged that was not anticipated when we wrote our initial proposal was obviously COVID. And to some degree, we are also trying to respond to these current developments and have a meaningful contribution there. Again, that is one of the projects of Daria, one of the more abstract conceptual studies. Simply asking the question, what do laws do in a time of crisis? Laws are setting general standards. They describe what should normally happen. What degree of flexibility can they have, should they have to respond to things that have not been anticipated and are in a way off the scale, are not within the normal flexibility that you can use to adjust to things. And what does that mean for the regulation of technology? So for instance, if all legal rules come with unless there is an emergency exemption, an unwritten one, what does this mean in my trust to disclose my data now? Yeah, I think one of the things COVID tracking, that debate has shown us is that some guarantees that you might have relied on when making the decision originally to share data about yourself can be overwritten in cases of a national or international crisis. So what does that mean for the trust that we can put in regulation, or the trust that we can put in the system if it is dependent on regulation? If none of them, these rules are categorical and always subject to a potential override. And at the same time, how can we regulate for crisis situations? There are legal techniques like sunset clauses, for instance. There are ways to limit deviations from the norm during times of crisis. But especially in the UK and with our slightly odd non-constitutional setup, it is very difficult to make binding commitments because Parliament can't bind Parliament as a matter of constitutional principle. So these are some of the things that we are exploring in that research. How does technology regulation adjust in times of crisis? And what does that mean again for the question of trust that people can put into these technologies? And on a slightly more concrete level, we've been contributing to a white paper in the broader context of Ethical Digital Scotland, an initiative by the Scottish government, where we looked in particular at the use of autonomous and automated system in a post-COVID Scotland and in the court system. One of the consequences of COVID was a massive backlog in cases. It might take years to get back on top of all the disputes that have accumulated. There's a considerable pressure to use automated pre-screening and triaging methods more extensively to assist with that. So for instance, to use technology to deal with straightforward cases in a purely automated fashion, award certain types of fines just to relieve the burden. And that feeds back into this notion of technology in a time of crisis. We might be willing to do things here exceptionally until things go back to normal because of the dire need. But how can we make sure that things really go back to normal and these do not become the new normal? And despite their various shortcomings and limitations, become deeply embedded in our justice system. Another strand that emerged as a sort of cross-cutting theme is the intersection of AI, intellectual property, and transparency. One of the key functions of our intellectual property system, in particular the patent system, is not just to reward innovation, but also to create transparency. The deal with a patent always is you get a monopoly for a limited period of time in exchange for disclosure, in exchange for transparency. So there's a strong connection here between transparency as a way to generate trustworthiness, the IP system, and AI. And we also find it in the other way around. We have clear examples of AI deployment in an untrustworthy and intransparent way because the developers claim intellectual property. The infamous Compass case from the US, where an AI was used for sentencing support decisions, and when the lawyers for the parties affected tried to scrutinize that system, very essentially told, sorry, the court doesn't own the software, that comes from a third party. That third party invokes their intellectual property and their trade secrets, you are not allowed access to that information. In concrete terms, we are working at the moment as a possible coordinated TAS or response to a consultation by the UK Intellectual Property Office. And we will also participate at a consultation meeting in November on patent law and AI to be able to have another avenue of input into that process. And we are also working on a paper, some of us, on explainable AI and patent law. And there the question essentially is, what degree of transparency can we create through explainable AI if the AI is an innovator? That is, broadly speaking, the topic. Finally, a cross application project. One of the underlying ideas from the beginning was that the designer becomes a new focal point of regulation, that there are now new and enhanced duties by designers of AI to develop law-compliant, ethically compliant tools. And for that, it would also obviously be helpful to have computationally legible and intelligible version of the law or of ethical standards. So that question of to what extent can we formalize the relevant provisions, to what extent can they be implemented directly in the code, is another cross-application question that we have. And one of the things that happened in that context is in September, the IEEE working group on ontological standards for ethically driven robotics and automated systems, of which I'm a member, and have been feeding some of our research into, gained first is a board approval, so it's now an approved IEEE standard, and also, to my delight, was awarded the SA Emerging Technology Award. So that was particularly well received, and there are ongoing discussions on how we can exploit that work from an academic perspective. And next week I'll be in a meeting with that working group where we will discuss also potential follow-on projects, and cybersecurity, ethics, and AI are emerging as one possible way to take that to the next level. We submitted a paper on a lightweight formal model for road traffic law and compliance checking for AI that was in conjunction with the ISAC project. Essentially, its aim is to help car designers, car developers to see which of the road traffic laws are affected by their design decisions. A particularly nice question that emerged from that had to do with with seat belts. In a conventional car, it is the duty of the driver to ensure that the seat belts of any children in the car are fastened. It is questionable how that rule is to be interpreted if there is no driver any longer. So the submitted paper looked into that in a very lightweight way. But I also had a PhD student starting this semester who will be associated with TAS, who is looking into particularly ontology, evolution, AAV regulation. So you have an old world where there is such a thing as a driver, and there are rules that apply to this driver. And then the question becomes, what happens now? What can we say about the new world where that object disappears? What happens to all the rules that suddenly become either inconsistent or empty? And another thing that happened in that context, we began collaboration with Microsoft Research. They have developed a new programming language, Català, which is aimed in particular at making it easier for lawyers to communicate legal regulations in a quasi-formal or actually formal way to the developers. We are going to have meetings with them again next week to see where we can take this. So now to the two, running out a bit of time, to the two concrete fields of application that we have. One is medical systems. We are continuing and deepening, hopefully, our work here with Optos. There were already a couple of meetings. There is a more academic project in progress. One of the ways in which the law tried to create trust in the medical profession through things like the Apologies Scotland Act is to create a safe haven for apologies in case something goes wrong. And that paper and that mini project will look in particular at how that way of apologizing for something that went wrong changes when a medical AI was involved in the chain that led to a negative and adversarial outcome. We are looking at software as medical device as a sort of precursor template for TAS governance issues. And we are going to have a meeting that RAM organized, I think 2 weeks time, with the MAAS service and NICE scientific advice to get contacts to the regulator side of that field to see exactly how they are thinking at the moment about autonomous medical devices. And continuing that is particular work Robin Williams and the people in ISTIS are doing. They are planning together with us for a high-level workshop in December on key players from policy, regulation, design, and the technical communities. And in that context also have worked on a pilot study with the Scottish Collaborative Ophthalmology Network, e-research, SCON, and are now in the process of working on follow-up studies on that, how these types of digital technologies can improve access to diagnosis and treatment for rural and island communities. And again, for me, I'm going back to one of these things that I said earlier, that question, how different local communities and standards are differentially affected by these technologies comes very clearly to the fore here. What might be acceptable in a community that is at the moment totally excluded from services might still be more problematic within communities that without that technology receive a better service. So that question of subsidiarity and responsiveness to local conditions. In the automated transport field, we've submitted a paper on WP29, the proposed harmonized rules for cybersecurity in autonomous vehicles that's submitted to the European Journal for Information Law and Technology. And we are currently working at a follow-up paper on how the regulation of drivers rather than the regulation of technology might have to change in this space. So big focus of the discussion obviously has been on how do we make autonomous systems safe? What are the obligations of the manufacturer, developer? What sort of certification system is appropriate? The AI Act talks a lot about certification. What is less discussed is the certification of the user. And especially in the car space, we obviously always had driver's license as a precondition to use technology. And one of the questions we are asking here is, how does that change? What type of regulatory approach, what type of licensing do we need or can have when we deal with automated systems? And that was it. And I managed it exactly in 25 minutes, which surprises me no end, because I hardly ever stick to the allocated time limit. And when I now manage to stop sharing, that would be even better. Oops. Yeah, I suppose at this point, questions.
There were a number of questions in the chat, Burkhard. I don't know which of those you want to pick up. There was a big thread around how does this relate to the field work that's going on? What are the differences? What's in common? How should we synchronize?
That is a very good question, and I mean, it always was going to be a sort of a bit tricky, difficult one. We probably should have a closer feedback loops between the empirical side of studies, how the regulation works out in the ground, and from the more doctrinal one. Having said that, quite a bit of what we're doing at the moment still is preliminary stock taking, just trying to find the lay of the land and to identify which research questions are the most pressing, and also for which type of methodology is needed to respond to each of them. So that definitely is a question.
If I could add to that, Burkhard, I would say that there are people from Pillar 1 in the cross-cutting teams like myself, so I do work quite closely with Andy, who we chat regularly about what's being found in the empirical findings. And I think that's one particular point where we're sort of having that cross-pillar discussions and exploring opportunities for kind of collaborative papers and those kinds of things. So I think there are those routes there which we're exploring. And
I mean, one thing I would hope, and that's also some bit what I picked up in some of the chat. I couldn't look at the chat while talking. That my poor little brain doesn't manage this type of double work any longer. Possibly once we are getting back to face-to-face sessions, some of that will become more natural than in the somewhat artificial Zoom environment, which doesn't always lend itself to that. I mean, I one just again scrolling through some of this, and I totally agree with Stuart, and that is definitely one of the emerging themes again, or issues again for me, that the way regulation still thinks about this is treating things as objects and objectifying them. And that was also one of the things that came out in the ontology standards for AI. This is almost an inevitable tendency to focus on objects that are fixed in a specific way rather than in constantly changing systems. And that definitely is part of, I think, the critique of some of the existing regulations. And again, I mean, one of the examples I mentioned was the traditional driver's test, which takes a snapshot of your ability, and once you have that, you are presumed to be able to drive a car unless something catastrophically bad happens and you get penalized for it. And that means you can have lots and lots of really bad but lucky drivers on the road. Within an AV system, we could think of something that is considerably more dynamic and gives a more accurate picture of the changing interaction between drivers and their car. So it's not, is the driver competent, it's not, is the car safe, but is the unit between these two competent. And that could be a sort of progressive system that now becomes possible.
So Burkhard, are you aware of any place where the regulation focuses primarily on process and not on product? Yeah, because I mean, it's quite clear that, I mean, there was a recent thing, I think, was it with Tesla, where they did some kind of very significant update to the autopilot without informing the regulator, and I think they were fined for that. Is that right, Ram? That was the process, wasn't it? Yeah. And so that's a kind of process violation that's being looked at there, you know, in the sense that it's a relatively straightforward one, but it's saying that when you make a it was actually not making it was effectively counted as a recall, you know, that they you know, normally you have to inform the regulator whenever you do a recall, and so this update was treated as a recall. Yep. But they didn't. They didn't tell the regulator at all about it.
Yeah. Yes, I mean, in varying degrees, these things do exist. I think the law generally struggles with it simply on a conceptual level. There are examples where it tries to do these things, and some of them, again, are old and don't necessarily have directly to do with technology, but things that you might do to something you have that voids its warranty. Yeah, that's very close to this notion. Things change over time. Some changes are permissible, but some changes go beyond the initial specification to the degree that certain legal protections do not apply any longer. In the context of the AI Act, there's quite a bit of post-market surveillance that will play a massive role. So there you move to more continuous collection of data and information that then leads to responses, at least potentially. And we looked a little bit also in that context in the WP 29 paper on cybersecurity, which has a similar approach that not just the initial entity has to be safe and certified, but also certain types of updates. But again, I think it ontologizes this very, very quickly, because the update simply becomes another object. Yeah, in the thinking of the law that is then plugged on it. And that might not be the best way to think about these things. It doesn't look at all the other things that change together with the update. For instance, that the driver now might have to respond differently. It still tries to draw artificial conceptual distinction that in reality are problematic. So I would say the law struggles. There are examples where it tries to go into that direction, but they are never straightforward.
I think Peter makes an excellent point in the chat about the distinction between outcome-based law like health and safety and input or process-based regulation.
I think you also need to consider that when you're looking, consider scale and things in relation to these.
I mean,
I think that's one of the flaws in the UNECE regulations on automotive. Yeah, if you look at the number of anticipated cyber attacks on an 8-year lifetime of a vehicle, it's 250,000. Yeah, to do 250,000 updates, based on regulations in an AI area, for instance, over an 8-year lifetime that might have health and safety implications, is a it doesn't matter what your regulations are in relation to that. And arguably at the moment, the regulations may be cementing a situation that makes things worse rather than making them better. It would be disappointing if we didn't contribute appropriately to avoiding that situation.
Yeah,
no, I mean, a really important element that you need to look at. Together with the difference, you talk about drivers. Drivers, and you're right, I get a license, but I get bad drivers individually. I get bad AI systems globally.
Yes,
that's a different problem.
Absolutely. And again, I mean, to some extent, we discussed some of that in this paper on WP 29, because it introduces a system of type certification rather than individual token certification, which I'm not particularly happy about, to put it mildly, because again, as you and others have said before, that might mean effectively that lots and lots of things are on the road that are known to be dangerous, simply because the type is still deemed to be safe. So we also get here the sort of type token conflict potentially between the individual instance and the aggregate one. None of these things are, in that sense, totally new or specific to AI, I would say. Very many of these arguments were made exactly in the same way with the steam engine that was posing back in the 19th century some of these problems, and the modern certification system pretty much came out as a response as a response to that, including examples of regulation making things worse, because again, regulation is very often part of the political process, response to high-profile individual cases of a problem appearing, and as a result, might respond to that one known problem in a way that creates many, many more risks and dangers elsewhere.
Mm-hmm. Mm-hmm. May I suggest we take one more question? I think Stuart has his hand up, and then we move to the break so we can try to get back to the schedule. Stuart.
Okay, so I had a quick remark, Burkhard, and then a question. One was on the steam boiler thing. You are aware of the Nancy Levison article, are you, about steam boilers? And so, yeah, okay, that's fine, good. I think one of the questions for me here, and I know that in, for example, in policing, the forensic exploration of mobile phones has posed real challenges because of the volume of information. Mm-hmm. And of course, what we're talking about here is, and as I think, as Andy mentioned earlier, we're talking about these things being developed using a DevOps environment, where there really are truly vast amounts of information generated on every single iteration of the system. Yeah, and so I think that this is one of the serious issues about, and it's not really explainability almost, it's almost graspability, or the possibility of being able to encompass the amount of information that is available, and actually what the significance of that is. Yeah, and I just wondered whether you'd started to look at that, and whether you've seen any kind of analogous challenges from, let's say, the challenge of forensic investigations of phones or whatever.
Oh, yeah. No, absolutely. I mean, that was, I think, technically speaking, on past results rather than for forward-looking future ones, which was the brief that I got. But one thing that also was published a few months ago was the new, the 5th edition of forensic handbook on forensic computing, where I contributed to the AI chapters in particular, exactly with partly that sort of concern. We are getting more data than we can make sense of in investigations. The backlog is massive. We create laws that probably will increase to that even further. Again, as I said, sometimes in response to some high-profile miscarriages of justice. So we had the abundant rape cases where evidence from mobile phones became so important. So we are probably going to tighten the pretrial disclosure rules, which will mean dumping even more data on the parties, which can't necessarily make sense of it. We had in Scotland the problem with the digital kiosk, which again was ill-conceived in numerous ways. So you're absolutely right. On the enforcement side and the litigation side, we have a real problem that we tend to have too much information and not enough ways to make sense of that in a legally meaningful way. Of course, obviously not all the information that you have ought to matter for what you actually want to describe. So yes, that remains on the agenda, even though partly because we've just finished getting the 5th edition of Mason and all electronic evidence out 2 months ago. Not something where we have a very concrete next project.
Okay. I suggest on that note, let's conclude this session.